here, give your attendance, and you shall be heard. State of the Commonwealth of Massachusetts, court is now open, you may be seated.
Thank you.
SJC-11093, L.J.S. versus J.E.S.
All right, let's proceed. Yes.
Good morning. Sandy Derlin of the law firm of Schmidt & Federico in Boston. I represent the appellant, J.E.S., the husband in this matter. I requested FAR on 2 points, which I'll address in reverse order. The first is the conclusion drawn by the appeals court in its decision that the alimony order in this case was not subject to Section 71C2 of the Internal Revenue Code.
Isn't that in fact all that we have taken further appellate review on, that one question?
You did, the court only took appellate on the tax issue, these 2 points that I'm going to raise.
I didn't realize it was.
The Section 71C 1 and 2 address the deductibility of support payments arising out of a divorce judgment. In this case, the judge allocated 2 separate forms of support, child support and alimony. He added the typical contingencies on alimony, death of the parties, and remarriage of the receiving spouse, along with the 4th contingency. And it's the 4th contingency that I suggest is the problem that triggers the application of Section 71.
Let's assume we agree that you're right. What do we do about it?
Well,
Up to the judge to sort of decide whether she wants to reconfigure?
Well, we requested that the trial judge, we gave the judge a suggestion that the alimony could continue past the period of time that's suggested in the section. 6 months is usually the operative term both before and after the triggering event, and we suggested going beyond that point. The trial judge has since retired, and I suggest the court could impose.
We just modify the order ourselves.
I think that was my suggestion to the trial court, the suggestion to the appeals court.
But before we do that, I take your point. I understand that even though this isn't the kind of support that the appeals court thought it was, which was undifferentiated, you actually do have differentiated support. And what you're really concerned about is that safe harbor provision that doesn't put you within the trigger so that your client doesn't get taxes. There are, however, other concerns looking at the facts in this case, so that if you do, for example, put the date at which alimony terminates, right, beyond a date, so it wouldn't be associated with a child-related event, and the house doesn't sell. What the proposed order and in your motion doesn't suggest is that there would be a concomitant obligation undertaken by your client to continue to pay the mortgage to the extent that the house doesn't sell, or something like that.
Correct.
Because
that is correct.
Obviously, the whole setup was to maximize appropriately the tax consequences beneficially to both parties. But if the house doesn't sell,
well, I don't think it was just the tax concerns. I mean, it was obviously to maximize the cash flow to the paying husband. But I also think that the trial judge was concerned about the youngest child's remaining in the marital home, former marital home, until his graduation from high school.
No, I understood that.
That will end, presumably, in May, I think, next year.
Right.
The safe harbor, we suggest, goes beyond that, so the benefit to the child will be met, and then the alimony could terminate, irrespective of the sale of the house. That is a variation on what the trial judge ordered, but it's clear, I suggest, that he was concerned about the home and the son.
I do understand your point, but I also see that the payments here include not only a hefty mortgage, but additionally an equity line. So I'm not suggesting that I know what the correct outcome is, but it wouldn't be necessarily the right thing just to adopt your suggestion of fixing a new date.
I can't deny that, Justice Duffley. It's clear that the concern is on the safe harbor. If that is addressed and the payment were linked absolutely to the closing on the former marital home,
Right.
that would still be a better outcome than the trial judge's decision here.
Right.
Secondly, I think the trial judge and the appeals court were concerned about, I think, the link between the actual sale and the contingency itself. And I think that the code in both the tax court cases that address this issue don't draw such a distinction. I think the tax court decisions and the regulations are clear that it's merely the triggering event. It's not the actual event itself. And the sale of the home is an uncertainty. It's unclear when and if that'll ever occur, as Justice, you just pointed out. But the reality is, it's the contingency that's inherent in the trial judge's decision that could raise the hackles, if you will, of the service and create the recharacterization which would harm the paying husband here.
Now, would it go all the way back?
Under Section 6501A of the code, there is a 3-year period of time that the service is allowed to collect unpaid taxes. It's actually increased to 6 years if that unpaid tax is greater than 25% of the adjusted gross income of the paying taxpayer. I don't know if that would apply here. It's clearly 3 years. And since there's about a 4-year window between the judgment and the graduation date, if you will, 2009 to 2013, there's clearly a 3-year window there that could present a problem.
Mr. Durling, now I've accepted for the moment your argument that this is a contingency related to a child emancipation, but I actually couldn't find any tax letters or code or cases that decide this particular issue.
I didn't either, Justice. There are a laundry list of cases which talk about tax code cases which talk about support ending when the child moves out of the home, when the child turns 18, turns 19, and so forth and so on. There's actually nothing talks about the sale in and of itself. But I think that's the distinction can still be made. I don't think that is a meaningful distinction. I think that it's clear this has to do with the child remaining in the home through graduation, and I think that's the triggering event.
Wouldn't it even if it weren't absolutely clear, that the risk, given the language of the statutes, is sufficiently great that exposes you to this potential liability?
Yes, and what I find perplexing is that the remedy that we proffered, however constructed, is one of those situations where benefits can be had by both parties. There's no detriment here necessarily to the recipient's spouse, the wife, under our proposal to extend beyond to a date certain, or even to even a different approach, provided the safe harbor, the 6-month, the triggering contingency is avoided, and that's what I'm seeking here today.
Now, the only detriment would be if there were any uncertainty as to whether the son would be graduating from high school, but I gather that...
That's true. Jessica, that's true, and and that is uncertain as I stand here today. But for all intents and purposes, he is on track.
But the record reflects they're both good students,
Yes.
so I expect that's not going to be a problem.
I don't anticipate there being a problem, and I can't speak specifically, but I do know that at the time the record was created, the child was a good student, and for all intents and purposes should graduate with his class.
As currently written, it provides that upon his graduation, the house is put up for sale, right?
Correct.
And then the alimony drops.
Upon the sale.
Right?
The
Upon the
alimony
sale.
drops, not when it's listed, but when it's sold.
Okay. And so you're proposing that happen as of August 1, 2013?
And that date was chosen because it's linked to the one absolute we know under the contingency, and that is his 18th birthday. So that's a certainty. Assuming he survives and reaches 18, that'll be in January 2013.
Okay, so that's just more than...
It's more than 6 months out. What we don't know is when the house could sell. So it is, admittedly, it's an arbitrary date, but it is one beyond the one certainty that we know.
But are you proposing either August 1, 2013, or when the house sells, whichever is later? Is it that?
The proposal we said was not prior to August 2013.
But is your proposal contingent on the house selling as well?
It was not specifically, but that result would also satisfy the concerns we have.
Okay.
If there are no other questions from the panel, I'll rely on my briefs. Thank you, Your Honor.
Sir.
Good morning, Your Honors. Adam Aberton, along with me, Karen J. Wayne, on behalf of the appellee.
The solution that was just suggested, why isn't that a reasonable, fair, logical solution?
I would suggest, Your Honors, that Judge Cohen fashioned alimony and child support appropriately.
So did you think Judge Cohen intended that there be these tax consequences that counsel has pointed up?
I suggest that Judge Cohen took into consideration what was before him with 3 children, all 3 with the intent of going to college, with a home costing approximately $5,800 per month.
Counsel, everything that the judgment does say about the house clearly does take into account the fact that the husband would have an alimony deduction and the wife potentially could have a deduction for the mortgage because she's residing in a primary residence, et cetera. The question is, did Judge Cohen anticipate or want the husband, if the house, given this contingency, to owe money to the IRS to the extent of the amount that could be attributed to child support? Because it was the termination of alimony is related to an event related to emancipation of a child.
I suggest it's not related to a child-related event.
Okay, why don't we talk about that? Why?
Suggest that it is related solely to the sale of the marital home, and that because it's a property division issue and an alimony issue under 208 Section 34, that upon the sale of the home, the appellee in this matter no longer has the burden of the approximately $5,800 per month. Thereby, her alimony that she shall receive shall be reduced by $825 per week. I think Judge Cohen took that into effect, or took that into consideration at that time. Now, there was no tax experts, or for that matter, any testimony offered at the time of trial, or for that matter, at the appeal relating to this matter, but notwithstanding, the court took into consideration that this woman was going to bear the sole burden of a mortgage, of a second mortgage, of the property taxes and homeowners insurance on this very large, the largest marital asset that these parties accrued over the period of 24 years during the marriage.
But if the alimony doesn't drop until the house is sold, I just don't understand what's the burden to your client?
When you say burden to my client, Your Honor, my understanding of Chapter 208, Section 34, as it relates to alimony, it is a quotient of need and ability, and that is the ability of the appellant in this matter to pay and the need of the appellee. And in this case, I note, it's at least noteworthy that in the appellant's brief, that while they spell out the paragraphs relating to the income of the appellee in this case and how with more effort she would be able to receive more income, they lacked the actual part of the finding, Section 129, which demonstrates that the appellant in this particular matter has the ability to earn, as has been his history, an income of between $300,000 to $380,000. It's noteworthy because it is a quotient of need and ability. Until such time that this house is sold.
I don't think actually anybody is disputing that. We're really talking about whether, notwithstanding the fact that you say this isn't a contingency, the IRS might agree with you, and if they were to look at our decisional law, they would note that at least a few decisions say that the right to live in a home is child support. So there's a risk, potentially. So the question, I think, goes more to how would a safe harbor contingency be included that doesn't harm your client in terms of the amount to which she thinks she should be getting under the original judgment?
Your Honor's first question related to what happens if, in fact, we put a due date on this alimony to terminate. I believe my brother suggested August 1st, 2013, and the house hasn't sold. We then have a $5,800 total package of mortgages, interest, and taxes that is left to be paid solely by the judgment itself by my client, without the ability to pay it.
If that were changed to require him to pay the mortgage.
I would suggest that Justice Cohen took everything into consideration and took into consideration that if he was going to make the appellee in this case responsible for paying the principal, interest, and taxes on both mortgages, then in fact she would have the need to pay it respectively with the alimony.
If the IRS can recapture taxes, if that's the right word, recapture taxes, from the husband, attribute income to him that was not alimony. In other words, it was child support. There are tax consequences to him. Isn't there a correlative inverse tax consequence to your client would she be able to file amended returns and recover taxes that she had paid for alimony, which now should have been paid as child support?
Well, if in fact the Internal Revenue Service did recapture and caused this alimony, which is now treated as alimony, as child support, yes, my client would be able to amend her tax return and receive the so-called windfall that my brother refers to in his brief.
And
However,
could she do that for as many as 6 years?
I don't have the answer to that,
Could you
Your Honors.
give me a citation to that? Under the old code, I didn't think that was true.
I'm sorry, Your Honors.
Could you give me a citation to the code that supports your view?
I cannot, Your Honor. I know
Well,
that.
afterwards in a 16L, there might have been a change to the code, I'm not aware.
Okay.
Is it your view that the judge intended that your client receive the tax benefit arising from an adverse IRS determination against the husband?
I would suggest it's Your Honor's obligation, wherein you took the further appellate review, to determine what, in fact, would be a recapture and what wouldn't be. I agree with my brother, there's no precedent.
But why must we be deciding what the IRS law is? Isn't it enough for us to say there is a substantial risk that the IRS may find this and say, given the risk, the judge should have avoided that risk by setting a fixed date, especially where, well, let me ask you this. Let's assume you win. What happens?
Well, if the appellee prevails, this court has determined that, in fact, this particular set of facts does not meet the Section 71.
No, I know that, but I mean, let's assume you get that ruling. Because I mean, we can say that the IRS is not necessarily bound by what we say, is it?
No, it's not. Your
Okay,
Honor.
so the IRS can do what the IRS wishes to do. So let's assume that we say you're right, and the IRS, regardless of that, the son's going to graduate, I guess, correct?
Yes, and
So
he's looked at 11 colleges to date, Your Honor.
Very good. So upon graduation, the house is going to be up for sale,
That is correct, Your Honor.
and it'll be up for sale sometime in June.
Or sooner.
Okay, so it'll be marketed in May or June, and the hope is that it's in Newton? Wellesley, so it'll sell if it's priced appropriately, I assume. So by August, you'll have a closing, if all goes well. August or September, if all goes
Depending
well.
on the market, Your Honor.
All right, and so why can't the order be refashioned to make those fixed dates as opposed to a date contingent upon an event which we now know to be nearly certain, barring any serious health event?
Because I suggest to this court there is no risk that the Internal Revenue Service may recapture this income as child support as opposed to alimony as it's adjudicated, because it is related specifically to the needs of the appellee in this case, which is the duty to pay the principal, interest, and taxes on both mortgages. And that was what was taken into consideration at the time of the November 17, 2009 judgment, Your Honor.
Okay.
Is it just a sort of matter of principle that you're right on your view of the law? I mean, I can't see what the detriment is to the change.
I'm not suggesting whether I'm right or wrong, Your Honor. What I'm suggesting is that that Justice Cohen, along with Cipher, Granger, and Brown, did not determine that that would be a recapture event. Namely, that if there was this
No,
need
they
and
just
ability
determined
quotient-
that it didn't apply, which I don't think you think is the case either.
I'm sorry,
They just said this provision didn't apply, which I don't think you think either. Potentially, this is the provision that would potentially apply, but for the fact that you say that there is no contingency related to the child's emancipation. And maybe that would be true. The issue would be whether the IRS would think so. They might see it your way, that in fact the judge was really paying attention to where the child was living more than and tax consequences related to payments, allocating the burden so that each party would benefit most from the allocation.
I respectfully disagree, Your Honor. And the reason being is I still look at this as though Title 26, Section 7D1, C2 rather, does not take effect as a result of this particular judgment, because I look to 208 Section 34 that this is certainly an alimony case, and there's certainly a need and an ability to pay. On that, Your Honors, I rely on my brief and the previous decisions. And if there's any further decisions, I'm happy to answer them.
Thank you.
Thank you.